The FAA is trying to clean up the mess they made. By the time you see this video, the FAA should have published a notification of a new policy dealing with experimental aircraft. The new policy isn't just a minor change to old policy. This policy admits that the self-inflicted conflicts in the regulations and policies the FAA wrote have existed for decades. And of course, the new policy means that aircraft owners and flight instructors have to do yet more paperwork. And the policy only begins to address some of the real conflicts. And yeah, I'm sure that with all of the thought that they put into this, that they're getting it right this time. We're going to talk about how this new policy is supposed to make it possible for at least some aircraft owners to receive flight training in their own aircraft. And we're going to do that right now. Hi everyone. As I mentioned last week, the FAA managed to paint themselves into a corner a few weeks ago and are just now proposing solutions to make it possible to allow pilots to receive training in their own aircraft. Something that was already policy for decades, increased safety, but that the FAA took away from the community in their enthusiastic push to shut down one warbird operation. I'm going to try to put up a card so that you can link to the video that goes into more detail about the implications of the court ruling the FAA pursued. The policy that they're adopting illustrates glaring problems with the agency and inconsistencies in rules and policy. The first glaring problem that this illustrates is the fact that the FAA was blindsided by their own actions. Someone at the agency should have been able to see ahead of time that if they were going to go to federal court and argue to a judge that flight instruction is something done for higher compensation, that it could negatively affect aviation safety on a larger scale. In fact, it appears that some of the big aviation associations did see that ahead of time, warned the government, but the FAA failed to heed their advice. Moreover, the agency didn't prepare for the work they would have to do if they were successful in their court case. And now they are playing catch-up and will be for years. Let's get into the notification of policy. By the way, this isn't really something that the public gets to comment on before it is made official. The regulations get a comment period. Instead, policy is done by fiat. The theory is that the agency is just explaining how it is going to enforce regulations already in place. They start off with a summary. This gives us a taste of the joy to be found within the document. This notification provides clarification on flight training for compensation in certain aircraft that hold special airworthiness certificates included limited category, experimental category, and primary category aircraft. It also provides guidance on how flight training for compensation can be accomplished in these aircraft in compliance with regulations and establishes a process for owners of experimental aircraft to obtain a letter of deviation authority to receive and provide compensation for flight training in their experimental aircraft. Now we'll skip down to the background since this tells the FAA side of the story. On April 2, 2021, the United States Court of Appeals for the District of Columbia Circuit dismissed a petition for review of the FAA's emergency cease and desist order against Warbird Adventures Incorporated and Tom Richard, hereinafter Warbirds, ordering that they cease and desist from operating their limited category aircraft in violation of Section 91.315 of Title 14 of the Code of Federal Regulations. In this case, Warbirds maintained a publicly available website that advertised opportunities to fly in Warbirds limited category aircraft at upcoming air shows and allowed members of the public to book flights in exchange for substantial amounts of money. Section 91.315 states that no person may operate a limited category aircraft carrying persons or property for compensation or hire. I have to say that for the FAA to make a point that the company was booking flights for substantial amounts of money is a little telling of the FAA mindset. For those familiar with Warbirds, it takes substantial amounts of money just to keep them flying. Before the court, Warbirds argued that it was conducting flight training for compensation in its limited category aircraft, which it claimed is not prohibited under Section 91.315. The FAA responded that, under the plain language of Section 91.315, flight training for compensation constitutes operating a limited category aircraft carrying a person for compensation or hire and, therefore, is a violation of the regulation. And this is where the FAA created a problem for themselves and the flying community. They argued the plain language of Section 91.315 without realizing, or perhaps just ignoring, where that argument would take them and how it would expose logical flaws in the FAA's very own decades-old regulations and policy. After the court dismissed the petition for review, several industry groups requested that the FAA publish a statement explaining the impact of the decision and providing clarification regarding flight training in general and training for compensation in certain aircraft that hold special airworthiness certificates. The FAA is issuing this notification in response to the request from industry. And there it is. There is the admission that the FAA didn't see this coming and wasn't prepared with new policy until the community requested clarification. The agency should already have known that their own rules and policies and how they would be impacted by their win, or did they already know and were just hoping that nobody else would notice? The FAA then goes through privileges of a pilot certificate and a flight instructor certificate versus experimental aircraft and how they could be operated. It's a little wordy, so I don't want to go through the whole thing here. I'll link to the entire document in the description. But the very last paragraph is worth noting. The distinction set forth in FAA Order 8900.1, which the FAA explains gave authorization for instructors to instruct in student-owned experimental aircraft, is inconsistent with the definition of operate in Section 1.1 and the plain language of Section 91.319. Where a regulation and guidance conflict, the regulation controls. Accordingly, owners of experimental aircraft and flight instructors who have operated experimental aircraft for the purpose of compensated flight training without obtaining a LOTA, as allowed by FAA guidance, will be required to obtain a LOTA to remain compliant with the regulations. Oddly, or perhaps not, no mention is made of the fact that a sport pilot certificate holder specifically cannot act as a pilot in command of a light sport aircraft for compensation or hire, and that nothing in the sport pilot instructor regulations say anything to contradict that. Talk about plain language. So let's talk about the FAA's solution for people seeking to learn to fly their own experimental, limited, and primary category aircraft. But first, as we're going along here, if you are enjoying this content, please take a moment to give me an upvote. Your subscription to the channel and your likes for the videos are highly motivational to me. Thank you so much. Let's start with experimental aircraft owners. First, if you are a flight instructor using your own experimental aircraft for training, the procedure hasn't changed. You still apply for your Letter of Deviation Authority, or LOTA, to your local FAA Flight Standards District Office, or FSDO, using the existing guidance. What has changed is if the training is to take place in a student-owned experimental aircraft. In that case, LOTAs are now going to be needed, but will be issued from the FAA mothership. The FAA will accept requests for a LOTA electronically from an owner of an experimental aircraft or flight instructor who chooses to conduct training in an experimental aircraft. LOTAs, once issued, will define the scope of the flight training activity so that owners of experimental aircraft may receive and provide compensation for flight training in their aircraft, as well as permit flight instructors to receive compensation for flight training in an experimental aircraft. These LOTAs will prohibit owners and flight instructors from receiving compensation for any other use of the aircraft in which the flight training is provided. To obtain a LOTA, owners of experimental aircraft and flight instructors providing flight training in experimental aircraft may submit a request to the following email address. Applicants seeking a LOTA through this process must provide the following information: name, address, email address, pilot certificate number, flight instructor certificate number if you're applying as a certificated flight instructor, aircraft registration number if you're applying as the owner of the aircraft, aircraft make and model in which you receive or provide instruction, aircraft home base airport if applying as an owner. The FAA will review the information submitted and issue a LOTA via email that reflects the conditions and limitations contained in this notification, as well as additional limitations required or in accordance with 91.319 H and I. And now for the owners of limited category and primary category aircraft. They have a different problem. Section 91.315 does not permit an individual to obtain deviation authority to conduct flight training for compensation or hire in a limited category aircraft. Same thing goes for primary category aircraft. The owners of these aircraft and flight instructors seeking to conduct flight training for compensation must obtain an exemption from the regulation. As with the process for issuing LOTAs to owners and flight instructors, the FAA will consider adopting a fast-track exemption process for owners of limited category and primary category aircraft seeking to conduct flight training for compensation in these aircraft. As with experimental category aircraft, the FAA will consider granting relief for flight training operations when compensation provided solely for the flight training and not for the use of the aircraft. The FAA wraps up the policy with the hope that a better way is possible. The FAA is considering a rulemaking that would enable the flight training activity discussed in this notification without the need to obtain an exemption or loader from the FAA. Considering. Let's hope they are considering it enthusiastically. Of course this is a bad idea because it doesn't do anything to improve aviation safety. It is just a stopgap measure that forces aircraft owners to generate paperwork because FAA regulations are lacking. So let's start a scorecard for the FAA. There are things that the agency could have been proactive about. After all, they were the ones who chose to go to court and then chose to make the argument that flight training is something that is done for compensation and is equivalent to taking someone for a ride in an aircraft for hire. I'm not even arguing the validity of the ruling. It does seem pretty common sense. But the fact remains that the agency opened a can of worms, and I'm just going to point out the ones that I see. I'm not an attorney, but plain language is plain language, and there aren't that many words in the regulations. Here's my list. These are the things that are at risk because of the FAA's court ruling. Most of this was covered in my last video. We have allowing pilots to be trained in their own experimental aircraft, allowing pilots to be trained in their own limited category aircraft, allowing pilots to be trained in their own primary category aircraft, allowing pilots to be trained in an instructor-owned primary category aircraft. This is a big one because the FAA was encouraging gyroplane companies to pursue primary category certification as an alternative to special light sport certification. That now seems to be wasted money on the part of at least one gyroplane manufacturer that followed FAA advice. Allowing sport certified flight instructors to instruct for compensation. Allowing general aviation certified flight instructors without second-class medicals to instruct for compensation. Allowing ultralight tandem instructors operating under exemptions to collect money for their services. Of these 7 big issues, the FAA has so far managed to slap a Band-Aid on only one of them. So far, this is primarily my own analysis. I've taken what I've seen, read the regulations, exemptions, court findings, press releases, and upcoming policy, and connected the dots. Am I missing something? Is something on the list that maybe shouldn't be there? Please comment below if you think I'm getting this issue right or wrong. Anyway, if you are interested in powered parachute flight instruction in either the Midwest or in Florida, please visit the link to easyflight.com in the description. Flight instruction is the very best way to get introduced to piloting, even if the FAA makes it more difficult. And please remember to grace me with your upvote. Thanks so much for watching, and blue skies.